Does your license need saving? Do the wise thing. Call Wise Man Lawyers. Does your license need saving? Do the wise thing. Call Wise Man Lawyers. Don't face that court alone. Let the Wise Man team get you back on the road. Does your license need saving? Do the wise thing. Call the Wise Man team at Wise Man Lawyers.
Alright, today I'm at Ipswich Magistrates Court. I specialise in drug, alcohol and traffic offending. A lot of the work's traffic offending, but a lot of the times it's just drug. My client today was charged with 7 offences, mostly related to drug and drug utensil possession. I'd previously acted for him for a drug driving matter about a year ago, but basically he's been charged with possession of 3 drugs, 2 of them being illicit, so one of cannabis, one of MDMA, ecstasy, and one of another prescription drug that he doesn't hold a prescription for. There was also a number of utensil and paraphernalia related offences, as well as one of failing to comply with the direction. He was told to go to the police station and give his fingerprints, which he didn't do, or he did, but he did it late. Worst case scenario, technically, is imprisonment, but given he's got no criminal history of this type, it was unlikely. So he could have gone there with a worse lawyer in town. It's unlikely he would have got jail for these offences with the lack of history that he's got. As I said, he's got 1 drug driving matter. I was able to get no conviction recorded on that occasion, but for drug driving, it's not a criminal matter, it's a traffic matter. But notwithstanding, I got no conviction recorded for him on that occasion, whereas this time it's obviously criminal offences and criminal convictions that he's facing. As I said, technically jail is the worst case scenario, but I suppose on a bad day with a magistrate that doesn't see drug offending as something that should be dealt with lightly, and with inadequate representation, I guess worst case scenario would be a suspended jail sentence or probation or something like that. But given the lack of history, I was here to push hard for fines only, but more importantly, given the field that my client works in, I'm not going to go into details, but he works in a defence-related industry, and because of that, there's certain defence and government security clearances that he needs to maintain. Drug criminal convictions would have caused difficulties, or most likely compromised or terminated those security clearances, so he was more concerned about the non-recording of criminal drug convictions than he was the actual penalty. Yes, as I said, there was previous drug driving, but I got no conviction recorded on that occasion, so I thought it was worth pushing for no conviction recorded on this instance, despite the fact, or notwithstanding the fact that there were 7 offences on this occasion. I got him to go to his psychologist, who he'd already been seeing. He was on a mental health plan, but I got him to go and get a letter from his psychologist addressed to the court, explaining his underlying issues, what he's trying to do to get on top of them, and the steps that he intends to take moving forward. I got him to get some character references based on a template we give all of our clients, guiding them through who it's going to be addressed to, key points that need to be covered, and whatever else they want to say about the client. I got my client to previously give me the information I needed to prepare my submissions, but as I said, I'd acted for him before, so I was familiar with him and his background and his underlying issues, but I just got him to update me with whatever's happened since then. I prepared comprehensive verbal submissions prior to today, met the client at court, we grabbed a conference room, I ran through what he can expect the police to say, the magistrate to say, me to say, and I went through what I was going to submit on penalty and why. As I said, technically jail was a worst case scenario, but I'd be misleading everyone if I was to say that it was at high risk of imprisonment given the quantities. So the cannabis was just shy of 30 grams. Basically, with cannabis possession, if it's less than 500 grams, it stays in the magistrate's court. If it's more than that, it needs to go to the district court, and that's when you get into sort of serious jail territory, because a lot of it's to do with the quantity rather than the type. The MDMA, it was such a small quantity that there wasn't a lot of emphasis put on the amount. It was sort of described in terms of a small amount. And look, the paraphernalia charges, unlikely you'd get jail for having a bong or a pipe, but they were in there as well. But I guess if he went there, as I said, by himself with a lawyer that didn't really know what they were doing, or they got a magistrate that was hell-bent on, punishing people who were dependent upon drugs, you may end up with a suspended jail term or probation or something like that. But in any event, I was here to try and get a fines only, but more importantly, in my client's mind, notwithstanding that previous, was trying to get no convictions recorded. Basically, I made my submissions to the magistrate. I tend to just get to the point, just short, sharp, but substantive and deep, without prattling on or wasting the magistrate's time. I mean, I'm very cognizant of the fact that every minute I speak, a minute later the magistrate knocks off, so I try to just short, sharp, bang, bang, bang. There was a little bit of resistance on the recording of convictions, but just with some more sort of deeper submissions made by myself, I was able to persuade the magistrate. So the short version is fines only, no convictions recorded on all charges. So there were 7 offences, no conviction recorded on all of them, fines only for all offences. Obviously, if my client reoffends and comes back before the court, it'll get harder and harder to A, avoid the recording of a conviction, but B, avoid jail, particularly if the quantities are greater than the scheduled amounts that he had today. Short version is he's relieved, particularly with the lack of the recorded convictions. It doesn't impact his security clearances. He can keep his job, keep his house, etc. I'm Andrew Wiseman. Thanks for watching. Hi, I'm Andrew Wiseman from Wiseman Lawyers, Queensland's only truly dedicated drug, alcohol and traffic offence law firm. If you face loss of licence, loss of vehicle imprisonment, or anything in between at any court in Queensland, we can and will help you today. This is our specialty. This is all we do. Give us a call, 1300 947 352. I look forward to helping you resolve your issue today.
Don't face that court alone. Let the wise man team get you back on the road. Does your license need saving? Do the wise thing.